Further hearing in the application by the Northern Ireland Human Rights Commission and the reference.
I rise very briefly, my lady, just to say that we've put in a note, as promised, on German termination of pregnancy law with the attached guidance.
Could I just ask one question? As far as I've heard, no one has referred us to the actual debates in the Northern Ireland Assembly.
That's right, my lady.
The Bill of Rights doesn't apply to preclude us looking at them. Are they of no significance or interest in the context of this litigation?
Well,
I think there was something said about that in Re G, wasn't there, that the quality of the debate, it may be invidious, and we discussed it also in the Welsh asbestos case, but the quality of debate in a devolved assembly may, it's a difficult question, be of relevance. It certainly can inform you if you're thinking about institutional competence.
Indeed, my lord, I think that question falls into two parts. Does the Bill of Rights apply? It's certainly never been suggested by the respondents it does. I'm not for a moment going to suggest that I've grappled with the constitutional issues as to whether what was in mind in 1689 would apply, or whether the principles would apply. So I can only say it's never been suggested in this case it would apply. So far as whether the court...
You can hardly apply in a large number of areas because the devolved legislation requires us to question. Anyway, leave that
Indeed,
aside, yes.
But I feel, my lord, I might be straying onto complicated territory, which I'm very ill-positioned to answer questions on. So far as the quality of the debate, certainly for our part, we are not asking the court to have regard to that debate for any submission that the quality of the debate was poor. To be frank, I have no idea. I have not seen a transcript of that debate. I have not considered it in any detail whatsoever.
You mean the February 2016 debate?
I think my lord would be...
We've got it.
Yes, but I haven't read it, my
Yes,
lord.
we haven't.
I'm not making... I think, in answer to my Lord Mance's question, I am not making any negative comment on the quality of that debate. Whether my learned friends at no stage in any of this litigation have positively sought to rely on the content of the debate rather than the fact of the debate.
I would have thought that it was more, given that they are the people who are making the argument for institutional incompetence on our part,
Yes.
it would be for them to say, and look what a brilliant debate there was in the Northern Ireland Assembly, where all of these arguments were properly aired. I don't think it's a question that you need answer.
I'm grateful, my lady.
Could I ask Miss Leaven a question?
Of course, but not that one.
Not that one. I'll think of another. The definition of rape. For your purposes, does this include, as it were, statutory rape? Does this include every act of intercourse between somebody over 16 and somebody under 16?
My lord, it is only fair to say that when this claim was lodged and originally pleaded, what was plainly in the Commission's mind, and I think one would see that reflected, albeit implicitly, in the original forms, was non-consensual sexual crime, i.e. not what is known colloquially as statutory rape. It would include a 13-year-old or under who is not able to consent, but for the category between 13 and 16, where consent is possible, although it would of course depend on capacity in that age group, the case as originally pleaded did not encompass that, or was not intended to encompass that. It's not entirely clear, I think it would be fair to say, what Mr. Justice Horner, who of course made the declaration of incompatibility, whether he did encompass sexual offence of having sexual intercourse with an under 16-year-old. And obviously, in the light of the facts of JR 76,
Well,
which...
quite.
Well, indeed, that arose, or I don't know whether the actual factual matters arose before we started this action, but certainly the legal issue the legal case only arose after we started this action. But it would be wrong of me, on behalf of the Commission, to positively assert that when we started this claim, we did.
Well, thank you. It was the JR76 material and her claim in her statement that she'd been the victim of statutory rape that led me to want to clarify what your aspiration was.
Yes. Well, and my Lord, the court can imagine that in the light of the facts of JR76, we have thought long and hard about this issue. But I don't think I can say on behalf of the Commission that our aspiration in the original claim was to encompass what's known as statutory rape.
Thank you.
That doesn't mean to say that we can't think about it.
Indeed.
That's not a matter for you.
That's not a matter for me.
Yes, thank you. Miss Mountford.
My ladies and my lords, the statutory provisions
Impression is that she's not.
which we are considering mean that in Northern Ireland,
Indeed.
women who, if they are faced with the distressing circumstances before the court, choose to have an abortion, can't do that without facing the humiliation and stigma of a criminal conviction and the threat, at least, of the most serious criminal penalty available in our criminal law. And the issue which I will address on behalf of the UN Human Rights Council Working Group is whether the retention on the statute book of those provisions is contrary to Articles 3, 8 or 14 of the European Convention on Human Rights when these are read in the context of the wider international human rights law framework properly understood. And my submission is that the retention of a criminal sanction in these circumstances does violate the European Convention on Human Rights, and that this is supported by authoritative and up-to-date statements from important UN treaty bodies and distinguished jurists who are addressing the position in Northern Ireland in particular, and in two recent cases on what the international human rights law on this subject means in the context of fatal fetal abnormality in the Republic of Ireland, where the criminal provisions are very similar. And most, but not all, of the materials I'll take you to post-date the hearing before the Northern Irish Court of Appeal in June of 2016, and so they couldn't be taken into account by that court, but they are highly material to what it was deciding and what you will decide. Before I turn to those materials, I echo what I understand Ms. Leven said yesterday, that the body of international human rights law should be read as a coherent whole. And because Articles 3, 8 and 14 of the European Convention on Human Rights are the regional human rights provisions which track the general and specialist provisions of global international human rights law, so that convention should be interpreted so far as possible in harmony with those provisions of wider international human rights law. And I hope it's helpful. I've handed up a one-page vade-mecum, which I believe has helpfully been ascribed a vivid sticker. Yes. And that seeks to track where the provisions in international human rights law find their analogue in the European Convention on Human Rights. Of course, the precise wording isn't the same in every instrument, but it may be a helpful source of references. I know that you have been addressed on the extent of Lord Carnworth's observation in the SG case that the views of specialist UN international bodies are the most authoritative available statements of law, and Lord Wilson in Mathiasson explaining the idea of a harmonious reading, and his observations in the A and B case on the limits of that. It is my submission that the interpretive material that I'm going to draw your attention to is sufficiently focused on the issue in hand to shine a vivid light on it. What we are talking about here isn't the availability of state-funded abortion or the suitability in general of services provided for women by the state following rape or incest, or in the case of a serious fetal abnormality. What we're talking about is the criminalisation by the state itself, with the state threatening or imposing a punishment on a woman if she decides to undergo a medical procedure to meet needs that she has identified to terminate her pregnancy in the circumstances of rape, incest, or serious fetal abnormality. And the up-to-date and authoritative statements on the meaning of the relevant provisions of international human rights law, I'm going to get to them in a moment, but those provisions illustrate, and I say brightly illustrate, the three clear ways in which criminalisation of abortion in such circumstances violates human rights which are recognised in international law. The first way is this: for the state to impose a criminal penalty in these circumstances is a cruel, inhuman and degrading punishment. It's contrary to Article 2 of the Convention Against Torture and Article 7 of the ICCPR. And for this, so the second way is this: for the state to impose a barrier to women's access to safe and timely health care, which they want and need, that's a barrier of stigma and shame and illegality and expense. That violates their rights to dignity and bodily self-determination, as well as rights to access safe health care. Those are rights in Article 17 of the ICCPR and in Article 12 of CEDAW and the International Covenant on Economic, Social and Cultural Rights. Third, by placing that barrier of stigma and shame and illegality and expense in the way of obtaining medical treatment, when no man would face a criminal penalty for obtaining health treatment that he needs, the state stereotypes a pregnant woman as a vessel without agency, and that violates her right to enjoy health and autonomy without discrimination on grounds of her sex. I have a lot of references in my written observations. I'm only going to take you to the most recent authoritative and direct statements which show you that criminalising abortion in these circumstances is contrary to international human rights law. Firstly, there are two very recent and authoritative decisions and properly reasoned decisions on individual complaints by the UN Human Rights Committee, which are about the similarly restrictive regime in the Republic of Ireland in cases of fatal fetal abnormality. And those two cases both find clear breaches of the rights in Article 17 and the discrimination provision in Article 26 of the ICCPR, which corresponds to the European Convention rights which are in play in this case. So may I ask you please to turn up the Mellett case, which is in the Authorities Volume 15, tab 144, and it's on the memory stick at 5372. And Mellett was a case of fetal abnormality. The facts as submitted by the author are set out on page 5373. And you'll see the nature of her claims in paragraph 3.1 on 5374. She said the application of abortion law in Ireland subjected her to cruel, inhuman and degrading treatment and encroached on her dignity and physical and mental integrity by denying her the reproductive health care and bereavement support she needed, forcing her to continue to carry a dying fetus, compelling her to terminate her pregnancy abroad and subjecting her to intense stigma. So that was the claim that she brought. And in paragraph 3.4 on page 5375, you see that the criminalisation in Ireland of the abortion services she needed overwhelmed her with shame and stigmatised her actions and person, which served as a separate source of severe emotional pain. And then in paragraph 3.5, she explains the choices she faced between, on the one hand, letting the state make the deeply intimate reproductive decision for her to continue with a non-viable pregnancy under conditions of considerable suffering, and on the other hand, having to travel abroad for a termination. Neither option had the potential to preserve her reproductive autonomy and mental well-being. And by denying her the only option that would have respected her physical and psychological integrity, which would have been to allow her to terminate her pregnancy in Ireland, the state interfered arbitrarily with her decision-making. And in paragraph 3.15 on page 5377, she explains her claim under Articles 2, 3 and 26 of the Covenant, and asserts in paragraph 315 that laws criminalising abortion violate the rights to non-discrimination and equal treatment of other rights on grounds of sex and gender, which compel states to ensure that health services accommodate the fundamental biological differences between men and women in reproduction. Such laws are discriminatory also because they deny women the moral agency that is closely related to their reproductive autonomy. There are no similar restrictions on health services that are needed only by men. And in paragraph 319, she said that the state party's criminalisation of abortion reduced her to her reproductive capacity by prioritising the protection of the, quotes, unborn over her health needs and her decision to terminate her pregnancy. She was subjected to a gender-based stereotype that women should continue their pregnancies regardless of the circumstances, their needs and wishes, because their primary role is to be mothers and caregivers. And in its recent decision on this, the UN Human Rights Committee found that all those complaints were well made. In paragraph 7.4 on page 5386, the committee considered that the fact that the conduct was, well, 7.3, you'll see that the state, about 4 lines down, you'll see that the state party rejected Ms. Mellett's claim, arguing that the prohibition sought to achieve a balance of competing rights between the fetus and the woman, that her life wasn't in danger, and that there was no arbitrary decision-making process or act of infliction by any person or state agent that caused or contributed to cruel, inhuman or degrading treatment. And in 7.4, the committee considered that the fact that particular conduct or action was legal under domestic law didn't mean that it couldn't infringe Article 7 of the Covenant, and by virtue of the existing legal framework, the state party subjected the author to conditions of intense physical and mental suffering, and then it sets out the circumstances of that. 9 lines down, one of the factors is the shame and stigma associated with the criminalisation of abortion of a fatally ill fetus. And it observes that the court observes that many of the negative experiences described that she went through could have been avoided if Ms. Mellett had not been prohibited from terminating her pregnancy in the familiar environment of her own country. In paragraph 7.6, the committee noted that no limitation and no justification or extenuating circumstances may be invoked to excuse a violation of Article 7. That's because it's an absolute prohibition on cruel, inhuman or degrading treatment or punishment for any reason. And accordingly, the committee considers that taken together, the above-mentioned facts amounted to cruel, inhuman or degrading treatment in violation of Article 7 of the Covenant. Then, in paragraph 7.7, there's the explanation that the only option that would have respected Ms. Mellett's physical and psychological integrity and reproductive autonomy under the circumstances of the case had been arbitrarily interfered with. And in paragraph 7.8, and the committee considered that the balance the state party, that was the Republic of Ireland, had chosen to strike between the protection of the fetus and the rights of the women in the President's case cannot be justified. At the bottom of that paragraph, the committee noted that the author's much-wanted pregnancy wasn't viable. The options open to her were inevitably a source of intense suffering, and her travel abroad had significant negative consequences, which could have been avoided. On that basis, the committee considered the interference in her decision as to how best to cope with her non-viable pregnancy was unreasonable and violated Article 17. And then, in relation to Article 26, the claim of victim of discrimination, the committee noted that not every differentiation of equality, this is paragraph 7.11, that not every differentiation of treatment will constitute discrimination, and so on, but noting Ms. Mellett's claim that the state party's criminalisation of abortion subjected her to a gender-based stereotype on the reproductive role of women, primarily as mothers, and that stereotyping her as a reproductive instrument subjected her to discrimination. found that the differential treatment to which she was subjected in relation to other similarly situated women failed adequately to take into account her medical needs and socioeconomic circumstances and didn't meet the requirements of reasonableness, objectivity and legitimacy of purpose, and accordingly concluded that the failure of the state party to provide her with the services that she required constituted discrimination and violated her rights under Article 26. May I ask you also to note on page MS 5395, the concurring opinion of the late Sir Nigel Rodley in one paragraph, but in strong terms, underlining that the refusal of the state party to allow for terminations, even in this case, could not even be justified as being for the protection of the potential life of the fetus, because it was going to be born dead anyway. That was followed, and I don't need to take you to the details of it because it's very similar reasoning, but in another decision of the Human Rights Committee, also an Irish case about fatal fetal abnormality called Whelan. That's a decision of the 12th of June of this year. It's in the core volume at tab 1, tab 27, MS 1388, and the operative part is paragraphs 7.4 to 7.7 on pages 1400 to 1404. I also draw your particular attention to 4 recent concluding observations by UN treaty bodies on the situation in Northern Ireland itself. In view of the time, I won't take you to these, I'll just give you the references, but they all call on the United Kingdom to ensure that legal abortion is available in Northern Ireland in cases of rape, incest or serious malformation of a fetus. The first is the Committee on the Elimination of Discrimination Against Women's concluding observations on the UK of the 30th of July 2013, and that's in volume 18, 174, and the relevant paragraphs are paragraphs 50 and 51.
I'm sorry, 174, did you say?
Tab 174, my lord.
Tab 174.
MS 6243, the relevant paragraphs are 50 and 51, 6251 to 2. The same observation was made by the UN Human Rights Committee in its concluding observations in August 2015. That's Authorities Volume 18, tab 193, MS 4449, and the relevant paragraph is 17. MS 6456 states
they refer to fetal abnormality. You introduced these on the basis that they were commending abortion for serious fetal abnormality.
The CEDAW committee says serious malformation.
But the one we're on now is
yes,
fatal.
Is fatal, yes. Then I draw your attention to the Committee on Economic, Social and Cultural Rights.
Could you just give me the page reference to the relevant paragraphs? I don't think I've got it down right.
Yes. So the CEDAW committee is paragraphs 50 and 51, MS 6251 to 2.
6251 to 2.
Yes. The UN Human Rights Committee, August 2015, it's paragraph 17, MS 6456.
Thank you.
The Committee on Economic, Social and Cultural Rights, 14th of July 2016, is volume 18, tab 180, and the relevant paragraphs are 61 to 62, MS 6308. And that relies on the Committee on Economic and Social Cultural Rights General Comment 22 on the right to sexual and reproductive health from the 2nd of May 2016. And there, the relevant paragraphs are 25 and 28, MS 6351, and 50.
I'm sorry, the tab 180, paragraph 61 and 62, what is the MS number, please?
6308.
6330.
6308, yes.
And it refers back to General Comment 22.
Yes, and the relevant paragraphs of General Comment 22 on the right to sexual and reproductive health are paragraphs 25 and 28, MS 6351, and 54 and 58, MS 6358. And finally, given the very high proportion of sexual crime in Northern Ireland, which is against children, and I know you've heard about that, and to whom the principles in this case may therefore apply, can I draw your attention to the Committee on the Rights of the Child in its concluding observations on the United Kingdom on the 3rd of June 2016, and that calls on the United Kingdom to decriminalise abortion in Northern Ireland altogether. That's Authorities Volume 28, tab 285, MS 1620, and it's paragraph 64C and 65C, and it's in the context of child and adolescent health. So that wasn't very exciting, but they brings together the references. And what I say, these instruments and material support, is the propositions that in circumstances such as the present, criminalising abortion is cruel, and it is inhuman and degrading. And it's contrary, therefore, to Article 3, read in the context of international human rights law. Because even in very extreme circumstances like the Gefgen case, there is an absolute right to be free from inhuman and degrading treatment. It's not derogable, and that's the end of the matter. But even in the context of dignity and the respect for self-determination, which is qualified, and may theoretically be met by a countervailing social interest in preserving the moral norms of the country in which abortion occurs or saving lives, criminalisation of access to safe health care can't be justified in the categories of case before the court. Preservation of morals, and here it's the minority's morals, is actually theoretical in the context of Northern Ireland for the reasons that Ms. Leven has given. But in any event, by reference to the international human rights law norms, a woman's right to make decisions concerning her own health and physical and mental well-being, free from coercion and free from punishment, is a stronger interest in an actual life which is being lived than the social interest in preventing fetal destruction where possible.
Well, would it invariably be inhuman? I mean, supposing, contrary to the fact, there was in every doctor's surgery a notice of court to the effect that, of course, confidential information will be given you about the possibility of going abroad, which is perfectly legal to have an abortion and so on. We can't, as a matter of policy, it's not available in this country, but supposing it were handled differently, would it invariably be cruel?
My submission is that it is inherently degrading because it's actually an argument, I don't have this in front of the court because I'm talking about international human rights laws, but it's an argument that was adopted by Lady Justice Gloucester in a case in the Court of Appeal recently. It expresses the state's view that it is an offence for you to terminate this life, and that is degrading. It undermines your choice. And in many of the cases here, it is actually cruel and inhuman. We've seen the facts powerfully put forward. So I say the social interest in preventing fetal destruction in Northern Ireland comes nowhere near as high as the right of the woman herself to physical and mental integrity.
The consequence is that all those who express the view that abortion is not permissible are, in fact, themselves expressing a view which is contrary to the legislation. Inhuman. You would have to categorise
anyone can express a view. It's the criminalisation of following through with your choices, because it's the imposition of that view to degrade you by saying you are a criminal. This is something that if you did it here would potentially open you to a life in prison. That's degrading and humiliating. So people can hold their own views,
right,
but it's the state imposing that on you and saying you may not make a choice about what your views are because that to do so here would be criminal.
If you express the view that it should be criminal, then...
Yes, that's an individual can express a view.
No, an individual can do that.
Yes.
What you're saying is that the state can't do that.
Not
back it up with criminal sanctions.
Not backed by criminal sanctions.
Yes.
It could say, it could express a case, it could try to encourage people not to, I suppose, but I'm talking here about criminalisation. It's the only issue before the court. And in any event, I would submit that the evidence from international human rights bodies here, and it's before the court, clearly demonstrates that criminalising abortion in Northern Ireland does not in any event save lives. It simply displaces abortion to other jurisdictions or the back streets. And I've put in World Health Organization data, which is in my client's thematic report on health and safety for women that shows that on the World Health Organization's estimate, there are 22 million unsafe abortions annually around the world and 47,000 deaths. That's in our written case at paragraph 36, which is MS 10,331. And our thematic report, the relevant paragraph, is at MS 6456. So it doesn't save lives. And if Northern Irish law does not criminalise refusal to have a caesarean, even of a fully formed, healthy 40-week fetus, capable of being born alive, and it doesn't, and it can't, consistently with St George's Healthcare Trust case, which Ms Rose took you to, then in my submission it is disproportionate and unfair to criminalise abortion in the cases before this court. In such cases, to prohibit termination of a pregnancy on pain of criminal sanction is wholly disproportionate to and contrary to the concept of dignity and autonomy. To require a woman to continue to carry a fetus in these circumstances is as abhorrent as it would be, for example, to require a woman to act as an organ donor on pain of criminal sanction. And the decision which I've taken you to of these expert and authoritative human rights bodies are unsurprising because they are the fulfilment and the articulation of the foundational principle which underpins all international human rights law, the principle set out in the Universal Declaration of Human Rights that all persons are born free and equal in dignity and rights. That's it. The equality guarantees in the international human rights instruments in general and CEDAW in particular are all necessary and particular applications of those principles to ensure that they are respected, protected and preserved in practice. But that's what it's about. And that means that a realistic and purposive approach should be taken to what is meant by equal dignity and respect for choice, what is meant by equal access to healthcare and reproductive rights, and what is meant by freedom from inhuman and degrading punishment, given that women are differently situated from men in relation to pregnancy and reproductive health. So to ask, what does that imply for the necessary legal framework concerning their reproductive choices, especially in the hard cases of rape or serious or fatal fetal abnormality?
I'm afraid, Miss Mountfield, you're over your time.
My lady, I don't think we started until 22, and I have about 2 more minutes, which I'm told I have 5 minutes by my junior who's clock watching. If I may have 2 of them, I will finish. May I?
You may have to.
Thank you. So to criminalise recourse to abortion in the circumstances of this case constitutes cruel, inhuman and degrading punishment, shows a discriminatory lack of respect for a woman's physical autonomy, which can't be justified by competing social interests in avoiding fetal destruction, and acts as a barrier to women accessing healthcare services which they want and need, not because they're not available or are disproportionately expensive, but because of legislation which says that a woman who does not carry a fetus to term, in the circumstances of these women, should be punished for making that choice. And whatever moral positions individuals may take, and they may, the law should not use criminal sanctions to instrumentalise women's bodies or control their decision-making as to how to use them. The key is the notion of choice. And in the difficult circumstances of rape, incest and serious fetal abnormality at least, that should be a question for a woman to make for herself. For the law to criminalise and punish, threaten to punish, a woman who seeks an abortion in these circumstances undermines that foundational pillar of international human rights, that everyone is free and equal in dignity and rights, by making such women who are already unfortunately placed unfree and unequal. And for those reasons, the working group supports the Northern Irish Human Rights Commission's appeal. I'm very sorry. I need to correct a reference. The Committee on the Rights of the Child concluding observations is on the supplementary memory stick at 1620. Thank you.
Thank you, Miss Mountfield. Thank you.
My ladies, my lords, before going into the much less emotionally charged territory of the reference, can I deal with some of the points that have arisen thus far this morning? Firstly, my Lord Wilson, referring to the JR 76 papers, adverted to the phrase that's used there, statutory rape. Well, it's quite understandable, of course, that that would be used for forensic effect, but it's a term unknown to our law. One often sees it in some of the North American jurisdictions. And there is no question of JR 76 being a case about rape. It's simply not relevant to the consideration that your Lordships will give to the Commission's appeal.
Mr Attorney, do we in fact have the Northern Ireland legislation that's relevant to what happened to the daughter in JR 76? I'm not sure that we do. We've got so much stuff.
No, well,
I haven't looked for it.
so-
It's obviously not the same as the 2003 Sexual Offences Act.
Not.
Yeah,
It's not. It's
which
not.
does use the term rape to
It does.
describe that behaviour.
But it's not. We know that there was no complaint of rape against the rather disreputable boyfriend of JR 76. And when one looks, I won't take the court to it in terms of time, but when one looks at the description, the relationship is described as abusive. But then there is an account of the relationship, and it's quite clear that there was no complaint that the intercourse.
All I'm asking is, what's the Northern Ireland law on this subject?
My lady, it's volume 23, I think it's tab 239.
Thank you very much. Those of us who wish to will look it up at our own sweet time.
Indeed.
Yes.
I'm grateful, my lady. Secondly, with reference to the note on the position under German law, as I read that, there is no provision in German law providing that disability or fatal abnormality is a distinct ground for abortion under German law. From the guidance, one has the impression that the impact of disability may sound on a health ground for abortion after the period of 12 weeks. Thus far, the law of Germany may be readily equated to the law of Northern Ireland. In other words, a disability, fatal fetal abnormality, is never in itself a ground for abortion. So in fact, when one thinks about it for a moment, the complaints that the Commission make about Northern Ireland law could, mutatis mutandis, be made just as readily against the law of the Federal Republic of Germany. Some discussion arose about the reliance that could be or was placed on the quality of the debate in the Assembly. We made reference to that in our written case. Let me give the court the reference. It's at Core Volume 1, paragraph 57, where we referred to informed debate, and that's at MS 8692.
Which paragraph?
It's paragraph 57, my lord. Plainly, and this is in the context of my own friend Ms Mountfield's submissions this morning, a key question for the court is whether a principled legal prohibition underpinned by criminal sanction on abortion engages the negative or only the positive obligations imposed by Article 3. Now, viewed at purely in domestic terms, in the so-called right to die cases, the answer is clear. See pretty. It engages the positive obligations only. And the Grand Chamber in A, B and C was fully aware of the issue and didn't resolve it, simply saying at MS 860, paragraph 164, whether or not such treatment would be entirely attributable to the state, the court considers that the facts alleged do not disclose a level of severity falling within Article 3 of the Convention. And certainly one can see that the mere existence of the criminal sanction on which my learned friend places such reliance simply doesn't advance the argument at all for the applicants in that case. If a case coming from Northern Ireland were to come before Strasbourg, obviously the court would have to make a decision one way or the other as to whether it was negative obligation or positive obligation. But the domestic trend based on the right to die cases has been it would be positive obligation only. In Millet and Whelan, there is no analysis of the positive-negative distinction at all. Nor is there any discussion of A, B, and C, which one would have thought would be a serious, carefully reasoned analysis relevant to both committees' consideration. A, B, and C matters for this court.
You know how the committees arrive at their decisions? I mean, they obviously meet and discuss a draft, but one has no idea what the input in that draft is or where it comes from.
Respectfully agree, my Lord. I mean, it's certainly nothing approaching this. I think it's Carl Llewellyn says that argued law is tough law. The product of the committees isn't tough law, even assuming it were law in any meaningful sense.
And Mr. Justice McGarry agreed with him.
Indeed. Respectfully agree, my lady. And of course, as Mr. Chairman reminds me, many of them are not lawyers.
Well, there are some very distinguished lawyers among them.
Indeed, but many of them are not.
What about the debate? We haven't heard anything about it, but you've just referred us to a paragraph. Would it be right to say, having glanced at it, that it took place along party lines? It wasn't a vote according to individual conscience.
It was, and in fact,
was it?
There was only one party that took up a party position, and that was Sinn Féin in favour of the amendments.
I thought we saw yesterday a letter from the DUP saying the DUP will be voting against this.
Yes, but in terms of the announced position in the debates, the only one that I recall is that of Sinn Féin. And
what was the breakdown of the voting?
Breakdown of voting, I'll be taking the court later simply to look at the numbers.
Give us just a better appetite.
Authorities, volume 22, and one has the party position of Sinn Féin at MS 7751, and one has the Amendment 61 vote at MS 7788, and also the Sexual Crime Amendment, which was Amendment 68 on the same page. So, I speak with some delicacy, but no doubt my Lord Kerr can tell your ladyships and your lordships the party affiliation of each member in the lobbies, or I can have a stab at it.
Well, you've got plenty of other things to do, Mr. Attorney, today.
We have,
yes.
we have. But certainly, and I'm grateful to my Lord Wilson, the only two parties who took a party position were Sinn Féin expressly in the debates, and I'm grateful to my Lord Wilson. Obviously, the press statement from the DUP indicates they took a party position also.
Since they're the two major parties in the Assembly, that's quite significant, isn't it?
It is, but one on each side, my Lord.
Oh, yes.
So,
all the more significant on that account, arguably.
Possibly, but precisely what significance is a question.
That'll be a matter for us to...
Yes, indeed, respectfully agree. And can I invite the court just to look again at the SPUC authorities, because one has there the Beijing platform, to which frequent reference is made in a number of the CEDAW general comments. Again, unhelpfully, this arrived late, and It doesn't have an MS reference, but it's the larger of the two files that came. Well, I certainly saw them on Monday, and it's at tab 16. I'm sorry, yes, tab 15 of the SPUC bundle, and it's the last page, and it's K. And plainly contemplates, the court will wish to read that for itself, contemplates that abortion may be criminalised. The sentence beginning, in circumstances where abortion is not against the law, such abortion should be safe, contemplating that it may be against the law.
I'm sure, Mr. Kenny, you're going to move to your reference. At the moment, you seem to be replying to the appellant's reply.
No, I'm not replying to the appellant's reply. I'm replying to Minister Ms. Mountfield of this morning, which comes unusually. We make no complaint about that.
Well, for my part, I think that you should move fairly promptly to the reference.
Well, I certainly intend to, my lord. Finally, then one sees that states should consider reviewing laws containing punitive measures against women who have undergone illegal abortions. So the obligation is to consider criminalisation. And of course, as we know, that was done very recently, February of last year, in the Northern Ireland context. So, anxious as I have ever been to adhere to my Lord Kerr's exhortations, can I invite the court to...
Not always in evidence.
Oh, your lordship does me a grave injustice. May I ask the court to look then at the issue of the reference? Now, our case on the reference is at Core Volume 1, MS 8721, 8746. It runs between those pages. And the reference itself is in Core Volume 3, Tab 34, MS 9792. Questions referred are set out in the schedule. Does Section 71 2BC of the Northern Ireland Act 1998 allow the Human Rights Commission to institute human rights proceedings within the meaning of Section 71 2C of that Act, other than as respects an identified unlawful act or acts? Secondly, does Section 69 5B, taken together with Section 71 2BC of the 98 Act, allow the Commission to seek a declaration of incompatibility under Section 4 in respect of an Act of Parliament which does not prevent any act identified as unlawful in proceedings brought by the Commission? 4 summary points. The 1998 Act enables the Commission to bring human rights proceedings only where it is possible to identify an unlawful act within the meaning of Section 7 of the Human Rights Act and Section 71 of the Northern Ireland Act, and there is someone who is or would be a victim of that unlawful act. If that dual requirement, that there is or would be a victim of an identified unlawful act, the Commission may litigate human rights proceedings about that unlawful act. The proceedings must relate to that unlawful act. If that requirement is not satisfied, then the Commission cannot litigate human rights proceedings. And that requirement is imposed for good reason, to ensure that human rights proceedings brought by the Commission are considered by reference to a concrete set of facts evidenced in the materials before a court. Because the Commission's materials in the present case identify no such act and no such victim of the non-existent act, it had no power to bring this application for judicial review, and the application should have been dismissed for that reason. Secondly, and more generally, Parliament has provided that issues as to the compatibility of legislation may be determined only in the context of human rights proceedings that have been properly brought. There is no doubt, let me offer this reassurance, Court after the Commission, there is no doubt that such issues can be determined in judicial review proceedings brought to challenge an act of a public authority alleged to be incompatible with the Convention rights. So, for example, where the public authority relies on Section 6.2 of the Human Rights Act as a defence, because primary legislation means it couldn't act otherwise than in the way complained of. But neither the Northern Ireland Act 1998 nor the Human Rights Act 1998 confer a freestanding right on the Commission to challenge primary legislation, which, for these purposes, certainly includes the 1861 Act, an Act of Parliament, and I use the term primary legislation, primary stormont legislation, with respect to the Criminal Justice Act, Northern Ireland 1945, even though that falls out with the definition of primary legislation in the Human Rights Act.
Would you, Mr. Attorney, be able to institute proceedings for a challenge to primary legislation without identifying an unlawful act?
No, my lord. In the present case...
Why not?
Well,
under Section 71(2), you're exempted from the requirement of victimhood.
yes, but that's with respect, because of the way in which that section has now been recast, it relates only textually to Northern Ireland legislation. So the reference to Section 6 and to Section 24 are to the relevant sections of the Northern Ireland Act.
Would it cover the 1945 Act?
No, they don't.
Well, that postulates that it underwent a osmosis or transition when it was amended to delete the reference to Section 69 from subsection 1 and put it into subsections 2B and C. Does it necessarily follow that the scope of subsection 1 was limited in that respect? It's rather odd that you had power before and you don't have power now.
No, but what we hope to show is, of course, that the premise on which the judgment of the Lord Chief Justice turns is a false premise. The Commission never had power to do as he finds they do.
Why not? Have we got a copy of the unamended Acts?
We do. We
Well,
do.
if you look at that, it refers in subsection 1, before the amendment, to section 69(5)(b), which on your case, or I think you accept, is wide enough, does it, to embrace law in the sense of primary legislation?
Yes, but the Commission at that stage was hobbled by the requirement that it itself be a victim.
No, it wasn't, because subsection 1 didn't apply to the attorney. Oh, the Commission was hobbled, yes. Sorry. But you weren't hobbled. And what I'm putting to you is it's a bit odd if you lost your power, which you had until the amendment.
But I didn't, my Lord, because the Commission's only route to bring proceedings is 69(5)(b). That section 71, says nothing about my power to bring proceedings. What it simply says is that general prohibition, no one can challenge an act of the Assembly, an act of the Northern Ireland Minister, unless he or she is a victim. That doesn't apply to me or the other law officers. But because Section 69 hasn't conferred any power on me to bring proceedings, it doesn't apply. So I should say, not that I'm empire building, but if the court should find that I do have power to have the occasional tilted primary legislation, then I'd be very grateful for that. But I don't, as it presently advised, consider that I do. So in the present case, no unlawful act by any public authority was identified, save for the Minister's, inverted commas, refusal to introduce a bill to the Northern Ireland Assembly, which, as we'll see, he had no power to do. Thirdly, a declaration under Section 4 of the Human Rights Act can only be made, firstly, in respect of an Act of Parliament which it is said operates to prevent the public authority acting as the convention rights require, and secondly, in proceedings properly brought in respect of that Public Authorities Act. Fourthly, nothing in what we submit prevents the Commission from exercising its core functions under Section 69. It can bring proceedings in which the compatibility of legislation can be challenged, provided it identifies an unlawful act constrained by the impugned legislation and brings evidence of a concrete set of facts before the court which disclose someone who is or would be a victim of that unlawful act. So, my ladies, my lords, having given those four core submissions, what I propose to do is, firstly, discuss the relevant legislation. Secondly, draw the court's attention to some key elements in the history and prehistory of this litigation. Thirdly, to discuss the approach of the Lord Chief Justice in the Court of Appeal. Fourthly, analyse the submissions of the English Equality and Human Rights Commission, which the court will have, and I should say that the court will be greatly assisted by those written submissions and by the small sheaf of authorities that come with them. And then fifthly, I will return to our printed case and make some concluding points. So, the legislation. To find the legislation in its original form, and for our purposes, Section 68 and 69, relevantly for this appeal, have not been amended in a way that matters. And one finds them in Authorities, Volume 5, at 1539, going over to 1540. So there shall be a body, Section 68, there shall be a body corporate to be known as the Human Rights Commission. It's a creature of statute. Section 69, Commission's general functions. Section 69.5, the Commission may give assistance to individuals in accordance with Section 70 and bring proceedings involving law or practice relating to the protection of human rights. So the Commission may help others to bring their cases, or it can bring its own cases. Now, since we're looking at this stage at the law as originally enacted, can I ask the court then to look at Section 71, which is the provision that was very substantially amended, and one finds it at MS 1616. Nothing in Section 62C, 24.1a, or 69.5b shall enable a person to bring any proceedings in a court or tribunal on the ground that any legislation or act is incompatible with the Convention rights, or to rely on any of the Convention rights in any such proceedings, unless he would be a victim for the purpose of Article 34 of the Convention, if proceedings in respect of the legislation or act were brought in the European Court of Human Rights. And Section 6, which is referred to there, is the section which sets out the legislative competence of the Assembly, and Section 24 is the provision which sets out the limits on ministerial competence. And for the Court's note, Section 6 is at MS 1469, and Section 24 is at MS 1491. So that's the legislation as it stood. And as we should see, when the matter comes before the House of Lords in the Human Rights Commission's case, arising from its attempt to intervene in coronial proceedings, the majority of the House of Lords found that this requires that the Commission itself satisfy the victim requirement. And I'll take your ladyships and your lordships to that in due course. So can we go back now to tab 33 and to section 71 in its present form. It begins at MS 1546.
Sorry, 15...
1546, my lord.
1506 or...
No, I'm sorry, my lord. 1546.
Yes.
Nothing in 62C. Immediately one sees that the reference to the Commission's part to litigate has dropped out. Shall enable a person to bring any proceedings, rely on the Convention rights in any such proceedings. And then subsection 2, which is unamended, subsection 1 does not apply to the Attorney General, the Advocate General for Northern Ireland, the Attorney General for Northern Ireland, the Advocate General for Scotland, or the Lord Advocate. And then 2A, and the beginning of the lex specialis in relation to the Commission's capacity. Subsection 1 does not apply to the Commission. So it doesn't stop there. 2B, in relation to the Commission's instituting or intervening in human rights proceedings, the Commission need not be a victim or potential victim of the unlawful act to which the proceedings relate. So the Commission is freed from the obligation that previously existed that it be a victim. Section 7.3 and 4 of the Human Rights Act, breach of convention rights standing, so that they're the provisions, as the court knows, that relate to the English and Scottish approach to standing in judicial review. C, the Commission may act only if there is or would be one or more victims of the unlawful act. And D, no award of damages may be made to the Commission. So there must be an unlawful act, and there must be a victim, or would be a victim of the unlawful act. 2C identifies what's meant by human rights proceedings, and they are proceedings which rely wholly or partly on Section 7.1b of the Human Rights Act 1998, or Section 69 5b of this Act. So they cover, in reverse order, the cases where the Commission is bringing its own cases or intervening in cases brought by somebody else. 7.1b, when it's intervening in somebody else's cases, and 69.5b, when it's bringing its own case. Importantly and helpfully, an expression used in subsection 2b and in section 7 of the Human Rights Act 1998 has the same meaning in subsection 2b as in section 7. So helpfully, understandably, one might say inevitably, there is a common meaning between section 71 and section 7 of the Human Rights Act. And one can quite see why that is so. The Lord Chief Justice, as we'll see in due course, proposes an insertion in 2C, A, Roman 2, of, in respect of unlawful acts. And his analysis is this would then preserve the Commission's ability to attack legislation. And we say, firstly, there is no reason to read down in that way. It's entirely unnecessary. The section works entirely well without it. but it does violence to what Parliament has done. If Parliament had simply wished to give the Commission the status of law officer in relation to standing, all it had to do was to add the Commission to subsection 2, or simply have section 2A. But Parliament hasn't done that. It's created a lex specialis of some particularity. And then one has some general provisions in relation to 2C. It doesn't apply to an act of the Assembly if the passing of the act by virtue of subsection 2 is not unlawful under subsection 1 of that, and a twin provision doing the same thing mutatis mutandis for section 24. So, having looked at the legislation, can I invite the court to look a bit at the history of this litigation?
Do we? I had a look at the explanatory notes, and have you looked at them? Are they somewhere?
Yes, they are. The explanatory notes are in this volume, and they.
There is one on the change, which struck me as interesting.
Yes, well, they are helpful, but I'm grateful to my Lord Mance. The explanatory notes are at tab 32, and there is background commentary. If one looks at the general comment paragraph 8 at 1442, the Act makes provision to extend the powers of the Northern Ireland Human Rights Commission. It amends the 1998 Act by granting 3 new powers to the Commission. These don't concern us. Powers to require the provision of information or document, person to give oral evidence, access places of detention, and to institute judicial proceedings in the Commission's own right, and when doing so to rely upon the European Convention on Human Rights. This will mean that the Commission can bring test cases without the need for a victim to do so personally. And then when one comes to look at the specific change affected, one finds that at internal pagination 7 of the document, MS page 1447. And this is particularly important in terms of giving colour to what Parliament intended. This section amends section 71.1.
Sorry, where are you reading from?
MS 1447,
Yep.
Paragraph 50.
Yes.
This section amends section 71.1 and inserts new section 71.2a, 2b and 2c into the Northern Ireland Act 1998. It allows the Commission to institute human rights legal proceedings in its own right, and when doing so to rely upon the European Convention on Human Rights, provided that there is or would be a victim, so far as that convention is concerned, of the unlawful act. So it's 3 things about that paragraph. Firstly, the emphasis is on the Commission extending a protective wing around an individual who needn't bring her or his own case. Secondly, victim requirement must be satisfied and there must be an unlawful act.
Well, the protective wing extends to the protection of possible victims.
Well, yes, but there's no magic in would be. You needn't actually suffer if you satisfy, in this context, the Article 34.
Is there any definition of unlawful act?
No, it has the same. We know simply that it has the same meaning as Section 7, but it isn't defined more than that. The 2 provisions simply have a common meaning.
But it couldn't be used to seek a declaration of incompatibility because ex apofficile would be no unlawful.
Yes, indeed. Respectfully agree, my Lord.
Did you say, Mr. Attorney, that the reference to legislation in Section 71 is a reference to subordinate Northern Irish legislation? And are you coming on to explain that to us?
I'm sorry, my Lord.
Did you not say that? Perhaps I
Yes.
misunderstood you.
No, the reference to the only reference, explicit reference to legislation, is Section 6 and Section 24, which are the legislative competence provisions and ministerial competence provisions, respectively, of the Northern Ireland Act. But the Commission's power was general in Section 71 as it originally stood. The Commission was simply taken out of that. Now, there is a debate. Could the Commission ever have gone after legislation other than Northern Ireland legislation? One doesn't have to decide that. The point is that it couldn't then, unless it was a victim, and it certainly can't now, unless it's an unlawful act. And of course, as my Lord Reid has helpfully pointed out, couldn't be an unlawful act because it's not unlawful.
Indeed. But I was simply looking at Section 71(1)(a), talking about nothing enabling a person to bring any proceedings in a court or tribunal on the ground that any legislation or act is incompatible with the Convention rights. So the draftsmen are thinking, well, there are two grounds for possible incompatibility, legislation incompatible or act incompatible.
Yes, act there, of course.
What is your submission about the meaning of the word legislation there?
Legislation, unambiguously, in its present form, legislation means Northern Ireland legislation.
Because that's the only legislation falling within the scope of Section 62C.
Yes.
And 24(1)(a) is a corresponding provision for executive acts.
Yes. Respectfully agree, my Lord.
Sorry, have you just accepted the proposition that the only legislation falling within Section 69 is Northern Ireland legislation?
No, I'm not sure I would necessarily be as mean to the Commission as that.
That would be bizarre, wouldn't
Yes,
it?
yes.
Because the purpose is to keep under review the adequacy and effectiveness in Northern Ireland of law and practice relating to the protection of human rights. That must include, surely, the UK Human Rights Act.
No, let me be clear about this. I mean, if, for example, there is some Edwardian statute, to take it out of the realm of this litigation, which does something awful in convention terms, if the Commission goes about it properly, and I emphasise goes about it properly, there's no reason why it can't bring that awful act before the court.
Well, when you say before the court, if it acts properly, what do you mean by that? What are the preconditions?
Well, it's got to have a victim and an unlawful act.
Yes.
If it pleads a victim or potential victim and it pleads an unlawful act, then in order to say that it could challenge legislation. But that's a problem, isn't it, for the reason that Lord Reid has just pointed out, because by definition there's no unlawful act if it's mandated by primary legislation or even permitted, or you're acting in pursuance of primary legislation. It says that in Section 6.
But then one is potentially in the territory, then one is potentially properly in the territory of Section 4.
Why are you properly in the territory of Section 4 when by definition there can't be an unlawful act, and you're saying the Commission can only bring proceedings if they can point to an unlawful act?
Yes, but the unlawful act isn't, and this is absolutely fundamental, my lady, the unlawful act can't be the bare existence of the statute. The unlawful act is the measure of enforcement or the acting upon it. So let's say, for example, not this case. A private citizen decides to sue a public authority for damages. Difficulty as public lawyers, often we have a kind of a deformation professionnelle and see things very often in judicial review terms. But let's try and step outside that. Let's look at an action for damages against a public authority, relying on a breach, say, of Article 5. Someone has been sort of trapped in a building and claims that they're entitled to damages, convention damages, for breach of their Article 5 rights. They sue, and the public authority says, but we had to keep you in our care for the relevant period because of Statute X. The report says, oh, well, that's not fair. In those proceedings, the two tasks of the judge will be, well, is that right? Does statute X really result in that detention? And if it does, then will fall to be considered the question of whether the statute is compatible with Article 5.
Yes, there can't be any question as to whether the Act is lawful. An Act of Parliament is the highest law.
Yes.
Subject to arguments about the EU.
Yes. But that's why the emphasis is never on. That's why taking and agreeing entirely with the analysis of Lord Reid, one can never simply, to put it in a colloquial way, have a pot shot at the statute book, at the Act on the statute book. There has to be the unlawful act of which one complains, which is referred to in section 71, 2b and c, has to be something which is done by a public authority, about which and gives rise or would give rise to a victim.
But supposing a victim of an illegal primarily piece of legislation and it recognises that they can't complain about an unlawful act because it would be said in answer, this is dictated by primary legislation. You say that's the one situation in which the Commission can't intervene or and assist?
Well, it can if it goes about it. So, for example, the Commission could do two things. The Commission could fund the person suing the public authority for the Article 5 breach, or, of course, the difficulty then is the Commission can't sue for damage, but then let's say it's a declaration that I was unlawfully detained. So the Commission brings a private law action, putting its protective wing around the litigant and saying, on the facts, Joe Bloggs was detained in breach of his Article 5 rights. You say that you had to detain him. We say that's a breach of Article 5. The Section 4 power of the court is thus in play.
Where's the unlawful act in that example?
The unlawful act is well, remember, the emphasis in Section 7 is someone who claims to be a victim of an unlawful act. So the person who claims, and the emphasis in Section 7 is on claim, will be the detention.
So the detention is unlawful, even though it's authorised by statute, in your example?
Well, that's why no domestic relief, save a possible declaration of incompatibility, will be given. And it's one of the difficulties that one sees about the transposition of a set of international obligations at the domestic level. Because, of course, in Strasbourg, one doesn't have to worry about the allocation of responsibilities among different organs of the state. Strasbourg simply sits back. Indeed, one has the executive government, in the last analysis, as a matter of practicality, picking up the tab on occasion for judicial acts, for which, in fact, formally, at a domestic level, they have no responsibility, yet at an international level, they plainly do. Strasbourg doesn't have to worry about that, but the draft of the Human Rights Act did have to worry about that, and Parliament had to worry about that. But we say that the solution that's been arrived at, the interpretive approach that we contend for, works. And it works, moreover, in a way that avoids the risks of abstract challenge.
But you've conceded to Lord Mance that Section 69(5)(b) does include a challenge to primary legislation.
No, it doesn't. What I've said, not that it's a freestanding right to challenge primary legislation. It can't be that. And the reason why it can't be that is because when one goes back to the definition of human rights proceedings, Section 69(5)(b), human rights proceedings means proceedings which rely wholly or partly on 2 Section 69(5)(b).
I'm wondering if this isn't. I mean, at the moment, I'm having a little difficulty following why it's so difficult. I mean, when one looks at Section 71, 2b, that's the first provision that deals with the Commission in relation to the Commission's instituting or intervening in human rights proceedings. We find out from 2C that that means proceedings relying either on Section 7.1b of the Human Rights Act or Section 69.5b of this Act. So in relation to instituting or intervening in human rights proceedings, the Commission need not be a victim or potential victim of the unlawful act to which the proceedings relate. So the whole premise is that the proceedings relate to an unlawful act.
Yes.
And therefore they cannot relate to something authorised by primary legislation.
Well, that is an interpretation more austere than I would necessarily contend for, because what I would say is that unlawful act, the focus of Section 7 is the claim of the unlawful act. And the claim of the unlawful act, which is what one is doing, the Commission is saying, you're acting unlawfully, Minister, by not doing certain things.
Well, that would be a different situation if the argument were that a minister was acting in violation of convention rights by failing, for example, to introduce a bill into a devolved legislature. That act of his, or omission to act, wouldn't itself be protected by primary legislation. And so that might be an act which could be challenged in principle.
That's the difficulty in this case, my Lord.
For example, as I understand it, your argument accepts that a challenge of that kind is in principle open, but you say it doesn't work on the particular facts in the context of Northern Ireland because none of the respondents to this judicial review application actually have the power to introduce legislation into the Northern Irish Assembly.
Yes.
Yeah, so you accept that in principle such a challenge might be brought, but you say because of the way in which the Northern Irish legislative procedures are set up, it can't be brought against any of the respondents here. It might, for example, perhaps be brought against the executive collectively, but not against an individual minister or department.
Well, what we say is that if, for example, there was a challenge to Section 28A, I'll take the court to that in due course, Section 28A of the Northern Ireland Act, which is the provision that requires ministerial code provisions that limit the power of individual ministers, then that would be a properly set up challenge, bound to fail incidentally, but a properly set up challenge to the Ministerial Act. But the Minister isn't constrained by the existence of Sections 58, 59 of the 1861 Act, nor Section 25 of the 1945 Act.
Yes. But so, just to be clear, one challenge we have here, the first thing these proceedings are looking for is a declaration that certain provisions of an Act of Parliament are incompatible with convention rights. And you would say those proceedings seeking that remedy don't fall within Section 71(2)b, and therefore the Commission has no power to bring those proceedings.
Respectfully agree.
Right. Insofar as the proceedings seek a finding that a department or a particular minister, the Department of Justice, has acted unlawfully by failing to introduce into the Assembly or place before the Assembly a legislative proposal that would have altered the 1861 Act, then the same argument doesn't apply. The answer has to be a different one, namely that those particular ministers simply don't have the power to table the legislation, and therefore the application fails for that reason, not because there is no standing to bring it.
It fails because there is no... you can't get relief against the minister
Yeah.
because the minister couldn't have acted otherwise.
Yes, so it's not a problem about standing, it's a problem about the availability of the relief.
Well, it is partly an issue about standing unless one is going for ultimately a declaration of incompatibility as respects the legislation which stops what you want happening from that minister.
Isn't there something more fundamental here? I mean, this discussion appears to lead to the conclusion that in relation to the United Kingdom, if you don't like a primary act of Parliament, then you complain that the government ministers are acting unlawfully in not having it changed, using their power.
Well, that particular form of application is blocked by Section 6 of the Human Rights Act, but the block only applies specifically to the Westminster Parliament.
But the existence of the blocking mechanisms in Section 6 is, we say, hugely instructive.
Yes, I see. 6,
about what should happen also with respect to the devolved legislatures, because while there is no formal exclusion, as there is in relation to Section 6.6, as respects them, nonetheless, in terms of good constitutional order, there are powerful policy reasons why the devolved administrations shouldn't be challenged with respect to their failure to introduce legislation. In due course, I'll show a rather extraordinary but important provision which gives certain powers to UK ministers in that regard, but we'll see that perhaps a little later. But, and can I simply draw attention apropos of the recent exchange with Lord Reid, the Court will wish to then perhaps particularly focus on subsection 4, 71, subsection 4, section, which is again, it's 1 MS 1547, and section 24(1)A, which is the prohibition on ministers acting in breach of convention rights, doesn't apply to an act which by virtue of subsection 4 of section 6 of the Human Rights Act is not unlawful under subsection 1 of that section, and does not enable a court unless the circumstances provided for there. So what that means is that where the minister is constrained in a way that the basis for bringing the claim, the cause of action, falls away, and one is left.
Where do we find section 24?
24 is a little further back in the same Act, and it is at 1491. So it's 24(1)A, which is of particular relevance to us. A minister or Northern Ireland Department has no power to make, confirm or approve any subordinate legislation or to do any act so far as the legislation or act A is incompatible with any of the convention rights. And that's the Northern Ireland specific version of section 6.1 of the Human Rights Act, if you will, and section 71(4) is the specific equivalent of section 6.2.
I suppose if the argument is that a failure to introduce legislation can be an unlawful act, there would then be a question as to whether how the victim test would be satisfied.
One of the issues that we'll throw out, ask perhaps rhetorically, but I hope with more than rhetorical effect, is, well, who is the Justice Minister's victim? Who's going to be a victim of the Justice Minister?
Well, I think the appellant's response would be anyone falling within the categories adumbrated by them.
Well, that wouldn't be right, respectfully, my lord, because he's done nothing to them, and he is not doing anything. He's not offering services.
But the premise of my lord's question was, if the unlawful act could be said to be the failure to introduce legislation to amend the impugned provisions, then the potential victim is someone who is going to be affected by the implementation of those provisions.
But the contingency, the series of contingencies that exist between one state of affairs and another would be apt to prevent the creation of victim in those circumstances. And in any event...
What do you mean by the series of contingencies?
The mere introduction of legislation, one knows because the piece of legislation, the parent piece of legislation that is the subject of the debates in February of last year, wasn't about abortion. So that these were amendments that were sought to be made to a piece of legislation that in policy terms was doing something else entirely. So introduce a piece of legislation and see what happens to it in the Assembly. No guarantee it'll get through, might be amended, probably will be amended, knowing the legislative practice of most representative institutions. But right now, if you claim to be, one uses the term in a colloquial sense, a victim of the present state of affairs in some way, you're not a victim of the Justice Minister. He's done nothing to you. He's withheld no service that you might reasonably claim. And of course, the other absolutely fundamental point, he's no power to do what you're asking him to do.
Yeah. Yes.
So I was then going to take the court, if I could, to the history of this litigation, and perhaps draw attention to or make 8 points. Can I ask the court to firstly start with Core Volume 1 and the statement of facts and issues, which is at 8496. Paragraph 2.
Sorry.
8496, Lord. See, ladies and lords, that first sentence in the Statement of Facts and Issues, paragraph 2, the Commission challenges the failure to provide certain exceptions to the prohibition on abortion in Northern Ireland. And then it draws attention to the provisions. So, that's what the case is about. The Order 53 statement, which is the second thing I'd ask the court to look at, is in Core Volume 2, MS 8902.
Eight nine two.
8902.
02.
02, yes, I'm sorry. And paragraph 1 identifies the applicant. Paragraph 2 gives us the Commission's views. Paragraph 3 seeks the following relief. It's a declaration pursuant to Section 6 and Section 4 of the Human Rights Act. Of course, Section 6 isn't conceivably in play here, but let's put square brackets around that. And Section 4 of the Human Rights Act, we submit simply no power to bring naked proceedings under Section 4 alone. And then a declaration which seems to be an interpretive declaration, and similarly an alternative declaration. And then the grounds, which simply speak to what was suggested of the combined effects, reference to being forced to travel in 4B, and then C, in refusing to amend. This is the only, the closest one comes to the specification of an unlawful act. In refusing to amend the current legislative provisions relating to termination of pregnancy, in these cases, the respondent has acted incompatibly with Article 3, 8 and 14, and who seek a termination in those circumstances. In the same volume, Core Volume 2, at 8905.
And can I just ask, the respondent referred to there is what? The Department of
Justice.
Justice.
I am a respondent to this appeal, but the only public body whose activity has been challenged is the Department of Justice.
Well, if it doesn't sound unkind, why are you here, Mr. Attorney?
Well, it does sound a bit, but yeah, I'll pass over that, my lord. I'm here simply because a devolution notice was served.
But you don't represent the executive.
No, I don't. No. I'm here as a statutorily independent law officer, pursuant to Schedule 10 of the 98 Act. Can I then ask the court to look at the notice of motion? And I ask the court to look at the notice of motion for one reason only, and that's that one has the date on which leave was granted by Mr. Justice Tracy, and one finds that at page MS 8905, the 2nd of February. Of course, as one knows, the leave hearing is the first, sometimes the only occasion when the issue of capacity is or ought to be considered. And as we shall see, a good deal of the material, whether it be submission or evidential, and there's a debate about that, comes well after leave was granted in this case. The notice of incompatibility is also in Core Volume 2 at 8908. And again, it's over the page, 8909. One has the reference again to C, in refusing to amend the current legislative provisions. That goes to the Human Rights Commission, Department of Justice, and to the Attorney General for Northern Ireland. Can I, fifthly, in terms of documents relevant to the history of this litigation, ask the court to look briefly at the first affidavit of the Chief Commissioner, also in Core Volume 2 at 8911. And I'm going to ask the court to look at 6 passages in this. The first is in paragraph 3, by section 71 of the Northern Ireland Act 1998, the Commission has the right to bring proceedings under the Human Rights Act under its own name without meeting the victim requirement in section 7 HRA. Well, just ask the court, that's, to put it on its mildest, that's unhappily expressed, that's not accurate. Paragraph 7, straightforward, the Commission sets out it seeks a declaration of incompatibility with respect to the relevant provisions. And it begins to look at its own standing in paragraph 15. It's the third bit I want the court to look at. In its own name, without the Commission having to meet the victim requirement as mandated by section 71, subject to the proviso that there is or would be one or more victims of the unlawful act. The Commission standing to its own name without a victim, pursuant to section 14, was confirmed by the Northern Ireland Court of Appeal. In fact, the Northern Ireland Court of Appeal didn't confirm that, but it said that there was a victim in that case. Fourthly, would the court look, please, at paragraph 29, and specifically at 8923. And at 8923, beside the date 7th November 2014, the Commission sent a pre-action letter to the Department of Justice indicating its intention to lodge proceedings unless the Department brings forward legislation to allow for lawful termination of pregnancy in the circumstances of serious malformation of the fetus and rape or incest. Fifthly, paragraph 50, which is at 8929, and there's a reference then to ongoing delay by the Department of Health to issue guidance on access to termination of pregnancy has been noted by the Commission. The Commission believes this is indicative of the inability of the Northern Ireland Executive and Legislative Assembly to address the matter with the immediacy required to prevent ongoing violations of human rights in the circumstances set out in this affidavit. So the Commission is plainly impatient with the democratically accountable branches of government. And at 52, sixthly and finally, this is a reference to seeking the protective costs order. The Commission has engaged with the proposed respondent to facilitate a non-contentious resolution of the issues, but this engagement has not resulted in the proposed respondent undertaking to act in a human rights compliant way. So again, it's the refusal of the Minister to bring this legislation forward.
But no relief is being sought in respect of that. The only relief sought is a declaration of incompatibility in respect of the primary legislation.
That's entirely true. At core volume 3, which is the moving through the matters relevant to the litigation history of this case, one has the devolution notice at 9786 in core volume 3.
Sorry.
9786. Yes, I'm sorry, lady. This is a slightly strange document because it seems textually to be a bit reversed. At the bottom of 9786, the applicant will argue that the Minister proposes to act illegally as he has no power to make, confirm, approve, or to do any other act to introduce legislation which would prevent women from accessing termination of a pregnancy in cases of serious malformation of the fetus or who become pregnant as a result of rape. The applicant will argue that the introduction of any such legislation is incompatible with Articles 3, 8 and 14 of the Convention. C, in particular, the applicant will argue that the Minister Department are bound by the provisions of the Northern Ireland Act 1998 and specifically Section 6 and Section 24 of that Act. Now, glossing this as best I can, it seems to be perhaps there's simply a textual error and that it's sort of, well, he should be doing it and he's no power not to do it. But either way, what is instructive again in C 9787 is that the reference is to Section 6, not strictly relevant because that's the Assembly and not the Minister, but Section 24, which is the Minister. So this is a claim about ministerial action. And if it weren't a claim about ministerial action, this document, the declaration of incompatibility, wouldn't exist. And it might be helpful to look briefly.
But before we leave this, I mean, reading A is saying that there's to be an argument concerned with the introduction of legislation which would prevent women from accessing termination. B is again concerned with the introduction of any such legislation, and C is all concerned with devolved legislation. So, I mean, it seems to be anticipating the introduction of devolved legislation, which, in fact, we haven't got.
No, indeed.
So is this of any significance?
Well, it's relevant. I suppose it can only be relevant in relation to the case because it wouldn't. It's a document that wouldn't come into being unless the court were considering the legality of the acts of the minister. If the court would look at Schedule 10 of the Northern Ireland Act 1998, which deals with devolution issues, it's at Authorities Volume 5 at 1602. Devolution issue means A, question whether any provision of any act of the Assembly is within the legislative competence of the Assembly. Doesn't seem to arise here. B, a question whether a purported exercise of a function by a Minister or Northern Ireland Department would be...
What's the MS number?
MS 1602, my Lord.
1602, yeah. So it's not tab.
Is or would be invalid by reason of Section 24. We've seen Section 24. And a question whether the Minister has failed to comply with any of the Convention rights, any obligation under EU law, and Section 27, which isn't relevant here. So this document wouldn't come into existence. The court wouldn't have issued it unless at issue in these proceedings was a challenge to ministerial action here on Convention grounds. And in...
Who generates the document?
The court. It's issued by the court.
I thought it was issued by the court, but does the court issue something drafted by the...
Yes.
Yes.
I'm not involved until I get it, so I step away from any responsibility for this document, at least in this case. So yes, obviously as a matter of practicality, the court typically, it's produced, I'm not sure what happened in this case, I suspect it was produced by the applicant.
And what's happened to this? What's happened to the devolution issue on page 9786?
Sorry, my Lord?
What happened to the devolution issue on 9786 to do with anticipated
what happens? Well,
legislation?
The next act that occurred was I entered an appearance to it, and one has in Core Volume 4 my response to the devolution notice at MS 9858. And 9858, paragraph 1, will see that devolution notice served, entered an appearance on the 3rd of March, and then rules of the Court of Judicature in Northern Ireland require a response, a substantive response to be made, and this is that response. And in one sense, the stuff here will be tiresomely familiar to the court because you've seen it from me already in this case. I mentioned the significance of the date on which leave was granted, the 2nd of February. Because it's relevant, it seems to be, in relation to a lot of the material on which the appellant relies. So, for example, if one looks at Core Volume 2 at 9388, that's the jurat of the AT affidavit, and one sees that it was sworn on the 23rd of February, and therefore couldn't have formed part of the proceedings at the time of the leave hearing. One has in the same volume Mara Clark affidavit, CV2 9187. and at the top that looks as if it's the Commission's received stamp, and in any event lodged in the court on the 4th of February. And thirdly, in relation to Sarah Ewart, if one looks at Core Volume 3, 9391, one sees that this submission is made, and again, I asked the court to note it's a submission, it's not formally evidence, but irrespective of that, the important point here is date. It's made following leave granted by the Judicial Review Office on the 12th of May 2015, so again, after the grant of leave. Fourthly, JR 76. JR 76, not relevant for the reasons that we said. Of course, it only comes, as my other friend was leaving, candidly accepts, well after these proceedings are up and running. Fifthly, if one looks, there is reference was made to correspondence which we've seen with the Department of Health in relation to the late production of guidance, it was claimed. There was, around about this time, I won't see the date in a minute, a challenge to the Health Department by an individual, BL, claiming that the department was failing unlawfully to produce guidance. So if one looks at tab 229, one sees her affidavit blanked out. Again, it wasn't part of these proceedings, but there were parallel proceedings taken by a private citizen solely in relation to the non-production of guidance. The important aspect of BL, I suppose, is that this is an affidavit which the applicant had to produce quite properly as part of the discharge of her duty of candour, because she was claiming that she was seriously incommoded by the non-production of guidance, but as is clear from this affidavit, she was able to obtain a termination of pregnancy in Northern Ireland.
Where is this affidavit?
This is in Authorities Volume 22 at tab 229. So
7963.
It shows the Bourne test working, in one sense, in Northern Ireland. And then one has the Ms. Phelan's affidavit, of course, which comes again just in these proceedings. And so take the court to its the SUP MS, page 115, supplementary memory stick, page 115. It's sworn on the 18th day of this month. And in paragraph 40 of her affidavit, she refers to the vote in the Assembly, and I've taken the court to the votes. She says that the DUP blocked the vote by raising a petition of concern and prevented a change which would have helped hundreds of families. In fact, that's simply not true. There was no petition of concern in the case. A petition of concern, as the court knows, requires a cross-community vote. This was a simple majority vote. There was no weighted majority, such as is required in certain circumstances under the Northern Ireland Act. My submission, had it been a cross-community vote, would have been that doesn't matter, because that's something which is rooted in the deeply thought-out, worked-out approach to the resolution of centuries of constitutional difficulty.
It would have been open, would it, to the DUP to serve a petition of right in this case?
It would have been when any matter
Didn't in fact happen.
Didn't happen.
Mr. Attorney, I'm sorry, I'm conscious I've been asking you rather a lot of questions
not at all,
this morning, but I'm very puzzled. You've shown us a few minutes ago the issues that have actually been, the devolution issues referred to us in Core Volume 3 at MS 9790. And the questions about the powers of the Northern Ireland Human Rights Commission.
Yes, my lord.
The first thing I want to be clear about is that the notice that you showed us that had been served by the appellant a few pages earlier at 9786, that has not been referred to us.
No, but that's a different devolution notice. So the devolution notice that one has 9786 to 97 just over the page to 9788.
Yep.
That's the notice issued by the High Court.
Yes. Yes. On the application of the present appellant.
Yes. The other devolution notice that's colloquially my devolution, the one instigated by me.
Yeah. And so the one at 9786 has not been referred to us.
Is not?
Has not been referred to us.
No, well, it's part of this case because it's in response earlier to the question from my Lord Kerr. That's why I'm here.
This is what brought you into the case.
Yes.
Yeah.
Having been brought into the case on that basis, you then had this bright idea that there was no standing anyway.
Yes.
Yes.
Now,
I'm sure I've committed a series of
compliment.
faults by saying yes to that.
Yes. Anyway,
well, so far as your devolution
so
notice
where is your
concerned,
devolution notice?
I'm wondering if it's a devolution, if it raises what is properly a devolution issue at all. Devolution issues are defined, it's Authorities Volume 5, page 1602, and they're questions to do with the competence of the Northern Irish Assembly or Northern Irish ministers or departments, or questions about accepted or reserved matters.
Yes.
Now,
This is a reference. The devolution falls into category 1D because the Commission, the Northern Ireland Parliament, wouldn't have legislative competence to abolish the Commission. So it is therefore, I can't turn up but I will turn up the reference to which schedule it properly falls into. But so it's a question arising under this Act about accepted or reserved matters. So the question under this Act is, what is the correct meaning to be given to Section 71?
Section 71 isn't concerned with accepted or reserved matters. They're defined in the schedule. So, for example, I don't know, foreign affairs, for example, will be, I imagine, a reserved matter. I can quite understand you're taking a point about the standing of the Commission as part of the merits of your defence to these proceedings. All I'm querying is whether it's actually, properly speaking, a devolution issue.
I can.
You may want to come back to this.
Well, I do, and there's a reassuring answer. I apprehend, because there are specific provisions of this Act which are included in one or other, either Schedule 2 or Schedule 3. So it's the question about the meaning of those provisions. That's how it's a devolution issue under paragraph 1D. It's no argument to a point to say, oh well, the Court of Appeal thought it was all right and the parties thought it was all right, because if your Lordship is right, well, your Lordship is right, and the issue doesn't arise as a devolution issue. But we respectfully submit it does, and have looked at it at one stage at least in terms of it falling under 1D. But I'll give your Lordship in due course the specific reference.
Thanks very much.
Can I just ask one question about the way you put your case on the complaint, insofar as there is a complaint that ministers haven't acted? Am I right? You haven't suggested that Section 6.6 of the Human Rights Act could, by extension or by analogy, apply to a devolved legislature?
Formally, it doesn't. But
formally, it doesn't. It says what it includes. It says what it doesn't include.
It does. Formally, it doesn't. I'm in entire agreement with that, my lord.
But that leads to a rather puzzling proposition that you can't complain about a United Kingdom minister failing to amend primary legislation, but apparently you could complain about a devolved minister doing so, subject to the particular problems which arise in relation to Northern Ireland. What about Scotland or Wales? Those problems wouldn't arise.
No, the barriers, the specific Northern Ireland barriers to ministerial action wouldn't arise. But the short answer is, I suppose, that introducing legislation, even if one could do it, is an act devoid of...
Yes, well, I mean, I've got your point about it's not treatment, it's not an infringement, but it seems rather odd, and I just wondered whether if one weren't asked to construe subsection 6, one mightn't be a bit more, go further than you've gone in your case.
Well, and as I suggested earlier in an answer to my Lord Reid, it would certainly seem appropriate to develop jurisprudence which sought, as far as possible, to give a protection to the devolved authorities in the respective jurisdictions.
I don't have it immediately to mind, but I have a feeling that there's a Scottish case where Lord Roger and Lord Hope questioned whether a failure to introduce legislation can be treated as an act for the purposes of the provision corresponding to Section 24 of the Northern Irish Act.
Well, we'll try and find that, Lord.
I think I might be able to find it over the short adjournment.
That concludes the 8 points in terms of the litigation history. From that history, we ask the court to note 5 things. Firstly, the judicial review in this case was triggered by a ministerial refusal, and while a declaration of incompatibility is sought, the act in respect of which the proceedings are brought is the refusal. I emphasise, proceedings have only been brought against the Department of Justice. Secondly, I'm now going to take the court to that part of the Northern Ireland Act to make good the proposition that he couldn't act, and one sees that in section 28A. So that's at 1494. And this was introduced in 2006 by the Northern Ireland St Andrews Agreement Act, and it brought about a fairly substantial change in Northern Ireland constitutional arrangements. It provided for a statutorily enforceable ministerial code. So Section 28A(1), without prejudice to the operation of Section 24, a minister or junior minister shall act in accordance with the provisions of the ministerial code. Section 5, the ministerial code must include provision for requiring ministers or junior ministers to bring to the attention of the Executive Committee any matter that ought, by virtue of Section 23 or 4, to be considered by the committee. And can I invite the court just to look at what that means? Section 20 is at MS 1485. And 3 is the committee shall have the functions set out in paragraphs 19 and 20 of Strand 1 of the Belfast Agreement. And if the court would, for now, take it from me that that refers to matters which relate to the preparation of the budget and matters which cross-cut the more than one department. 4, the committee shall also have the function of discussing and agreeing upon A, significant or controversial matters that are clearly outside the scope of the agreed programme referred to in paragraph 20 of Strand 1 of the agreement. That's the so-called programme for government. Or significant or controversial matters that the First Minister and Deputy First Minister acting jointly have determined to be matters that should be considered by the Executive Committee. So that's the obligation to produce the ministerial code, and the ministerial code is within the same volume. It begins at 1618, and effect is given to Section 28A(5) by 2.4. Paragraph 2.4 of the Ministerial Code, which is at 1626. Any matter which cuts across the responsibilities of 2 or more ministers, is significant or controversial and is clearly out of the scope of the agreed programme referred to in paragraph 20 of Strand 1 of the agreement, shall be brought to the attention of the Executive Committee by the responsible minister to be considered by the committee. And then there is some explanatory material about what's included, an advisory to ministers. So this is the Ministerial Code is subordinate legislation, at least as respects 2.4, whose content is predetermined by an Act of Parliament, Section 28A(5). The consequence it appears in Section 28A(10) at MS page 1495. Without prejudice to the operation of Section 24, a minister or junior minister has no ministerial authority to take any decision in contravention of the provision of the Ministerial Code, be it under subsection 5.
Sorry, you're reading from?
I'm reading from Section 28A(10), which is at MS 1495. I'm sorry, my lord. Can't do it on pain of loss of ministerial authority. If the third point that we invite the court to note in terms of litigation history is perhaps almost alternative history. If the court would look at paragraph 2.11 at 1628, one sees the Executive Committee agenda to MS 1628, paragraph 2.11 of the Ministerial Code. and that's the agenda for executive committee meetings will be agreed by the First Minister and Deputy First Minister, taking account of proposals made by Northern Ireland ministers. So the First Minister and the Deputy First Minister are the gatekeepers to executive committee business. And I speak subject to correction, but it doesn't appear that they were asked to put this on the executive committee agenda. And they, and the two of them acting jointly, had the power to do that.
Well, if the Minister receives a request from the Human Rights Commission to consider the compatibility of the impugned provisions, is it his obligation to bring it to the attention of the Executive Committee?
Yes.
Did he do that?
If he's considering action, he can't act without their approval.
Right. Well, did he do that, do we know?
I don't know, my lord.
Well, surely we can find that out.
Well, possibly, my lord, but as the court's aware, I don't act for the Justice Minister. But he can't do it of his own motion. The power lies elsewhere. Fourthly, neither the devolution notice nor the incompatibility notice constitute either together or by themselves new proceedings. And they're incapable of retrospectively or otherwise generating new litigation targets, unlawful acts. And this is really to deal preemptively with the point made by the Lord Chief Justice in his treatment of the case. We said, oh, well, you know, these notices went out. True it is, they did. But at that stage, the Commission had, or ought to have had, identified the unlawful act that it was challenging. So the unlawful acts can't emerge after the event. Or to put the matter another way, it might well be said, it might well be believed by members of the court that there are rather undesirable things happening in Northern Ireland. The existence of those undesirable things, if one considers them undesirable, doesn't constitute an unlawful act in respect of which these proceedings were brought. Fifthly, and it's perhaps a little odd that it's only now that we're doing it, but can I ask the court very briefly just to note where the 1861 Act and the 1945 are, because they haven't perhaps oddly been opened, as I can recall in the case before your lordships, your ladyships. Authorities Volume 5 for the 1861 Act at 1636. 1945 Act, Authorities Volume 4, 1418. And particularly in the case of sexual crime, I won't take the court to it, but the court will note that Mr. Justice Horner, who did make a declaration with respect to the 1945 Act, did not do so with respect to sexual crime. He took the view that the period up to 24 weeks was sufficient, and therefore, while that might operate with respect to the 1861 Act, it didn't in relation to the 1945 Act. Sixthly, and finally, in relation to the points that we make on the litigation history, and also in terms of perhaps alternative history, can I ask the court to again take up Authorities Volume 5, and to look at Section 26 of the Northern Ireland Act, and that's at 1492. and Section 26 is entitled International Obligations. Now, in truth, we say that this case isn't really about the European Convention on Human Rights, nor indeed is it really about what's contained in international human rights treaties. It's very much about, certainly on the appellant side, what is contained in the work of various committees. But Section 26 is an interesting and potentially important provision generally. If the Secretary of State considers that any action proposed to be taken by a Minister or Northern Ireland Department would be incompatible with any international obligations, with the interests of defence or national security, or with the protection of public safety or public order, he may by order direct that the proposed action shall not be taken. 2, if the Secretary of State considers that any action capable of being taken by a Minister or Northern Ireland Department is required for the purpose of giving effect to any international obligations of safeguarding the interests of defence or national security, or of protecting public safety or public order, he may by order direct that the action shall be taken. And interestingly, it's the only express provision, it seems to me, in this Act along these lines. In subsections 1 and 2, action includes making, confirming or approving subordinate legislation, and in subsection 2, that's the inaction, includes introducing a bill in the Assembly. Now, while the definition section, which is 98 of the Northern Ireland Act, excludes the Convention and EU law, and sees that at 1576. International obligations means any international obligations of the United Kingdom other than obligations to observe and implement EU law or the Convention rights. So while that exclusion exists, nonetheless, the Secretary of State is, of course, a Section 6 public authority, and if it were thought that on Convention grounds action was necessary, then she or he could be asked to take action under Section 6, and again, the Secretary of State wouldn't be trammelled in the way that a Northern Ireland Minister or Department would be. Can I, with thanks to my learned friend Mr. Chamberlain, perhaps deal with the issue that my Lord Reid raised. If one turns to Schedule 3, reserved matters, paragraph 42 includes MS 1599. Any matter with which a provision of this Act falling within the following subparagraphs solely or mainly deals. AA in Part 7, Section 68 to 69A, 69C to 70, 71 2A to 2C, and Schedule 7. So this is a question arising under this Act about a reserved matter. I now propose to turn to the approach of the Lord Chief Justice to the issue of standing, and one finds that in Core Volume 1 at MS 8783. And can I ask the court to read itself paragraphs 7 to 9? These paragraphs are the locus of the, what we say respectfully is the Lord Chief Justice's first error in relation to the issue of standing, where he concludes that the Commission had standing to challenge an Act of Parliament. Paragraph 9, I consider that Lord Hobhouse's analysis to be preferred. The Commission had to demonstrate that it was acting for the benefits of a person who could obtain victim status. That applied both to proceedings in which it was claimed that a public authority had acted unlawfully, and also to proceedings in which it was claimed that an Act of Parliament was incompatible with convention rights. I won't ask the court to go back to it again. I will inevitably have reason to do so later. But can the court simply take it that simply doesn't do justice to the clear text of section 71 as originally enacted? Section 71 as originally enacted made it clear that the Commission had itself to be a victim. And the matter, that's not just my gloss of an admittedly plain text. When the Human Rights Commission's efforts to get into and participate in baronial proceedings came before the House of Lords, that's the view of the majority of the House of Lords also. So can I ask the court to turn that up? It's Authorities Volume 2. And specifically the speech of Lord Slynn, page MS 791. Even closer to the question now raised.
Forgive me, the reference.
It's 791, and this is re Human Rights Commission in the House of Lords. It's Authorities Volume 2 at tab 12, my Lord.
Thank you. Paragraph.
Paragraph 11 at the bottom of page, MS page 791. Closer to the question now raised is the provision in subsection 5b that the Commission may bring proceedings involving law or practice relating to the protection of human rights, though that provision does not enable proceedings to be brought on the ground that legislation or an act is incompatible with a convention right, unless the Commission would be a victim for the purpose of proceedings brought in the European Court of Human Rights. So there, unambiguously, is the holding of a majority of the House of Lords in the Human Rights Commission's case that the Commission had to be a victim.
Is this my impression from accounts of the case, I haven't read the whole thing, is that this is obiter because the actual decision was about whether they could intervene in coroners.
Yes, strictly speaking it is.
See, yep.
But it bears such an obvious, we say, close and faithful relationship to the text that it's uncontentious, or ought to be uncontentious. The problem, if I may so characterise it, that arises in the Lord Chief Justice's discussion is the exchange, polite intrajudicial exchange that occurs in paragraph 23. And if one goes to paragraph 23, it has to be accepted that subsection 5A in itself is limited to giving financial and other assistance to individuals in accordance with section 70. Moreover, subsection 5B refers to bringing proceedings which, as the Lord Chief Justice said, is opposite to inquisitorial inquest for a coroner. Both subsections, however, indicate a role for the Commission in connection with court proceedings, even though in respect to proceedings in which it is sought to contend that legislation is incompatible with the Human Rights Convention, they can only be brought, it seems, if the Commission can show that it is a victim for the purposes of the Convention. Of course, that conflates. The Commission can, of course, assist others, in which case the Commission doesn't have to be a victim, but the litigant does. And that then promotes the riposte from Lord Hobhouse at 72, and he said, the person being referred to is not the Commission, but the person whom the Commission is assisting or acting for. In one sense, it's a dialogue slightly at cross purposes, but nonetheless, it's absolutely clear, we say, that the Commission itself had to be a victim. And further, it is to say the least paradoxical that the Lord Chief Justice relies upon Lord Hobhouse, who would have denied the Commission the power to even intervene in coronial proceedings if invited to do so. So Lord Hobhouse certainly isn't expansionist in favour of the Commission in any way.
Well, that sounds like a convenient moment, Mr. Attorney.
Thank you.
We'll look forward to hearing from you further at 2 o'clock.